Good afternoon. We are Team 3 and we are presenting the situational analyses for the Community for Creative Nonviolence versus James Reed. Next slide, please. The Community for Creative Nonviolence is an organization dedicated to eliminating homelessness in America. They are located in Washington, D.C. The CCMV entered into an oral agreement with respondent James Reed, a sculptor, to produce a statue illustrating the plight of homelessness for display at a 1985 Christmas pageant. Reed created the statue in his Baltimore, Maryland studio, and members of the CCMV visited him on occasion to check his progress and to coordinate the construction of the sculpture's base in accordance to their agreement. Next slide, please. Reed accepted suggestions and directions from CCNV as to how the sculpture would be configured and appear. He delivered the sculpture and joined it to its base on time. At this time, Reed was paid his final installment. Not once did either party ever discuss the sculpture, Not once did either party discuss copyright of the sculpture. Then both filed competing copyright registration certificates. Next slide, please. The legal issues of this case fall under the Copyright Act of 1976, Section 101. If it is a work for hire, CCNV is considered the author and owns the copyright, that is, if it was an employer-employee relationship. Section 101 reads, where work is 1. Prepared by an employee with the scope of his or her employment, or specially ordered for use as a contribution to a collective work as part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as and answer material, or for an atlas. If the parties agree in a written instrument signed by them, that work shall be considered a work made for hire. Now here's Erica with the verdict and rationale.
Okay, the Copyright Act of 1976 states that copyrights of a work belong to the author of that work. There is an exception, however, if the work is considered a work made for hire. In this situation, the employer is considered the author. This is a main argument in this case. In order to conclude whether or not this was a work made for hire, Judge Marshall needed to consider the status for employment of Reed. According to common law principles, Reed could be considered an independent contractor if he used his own tools and obtained materials independently, if the work was temporary, and if Reed controlled his own hours of employment. Judge Marshall was able to conclude that Reed was not a work made for hire by acting in the scope of an independent contractor. Therefore, the copyrights to the statue belong to Reed. Next slide. The rationale for this judgment had many determinants. Production aspects included skill level required for the project, which party provided the required tools to produce the work, and the location where the work was created. Employee work relationship included whether CCNV could assign additional projects to Reed during the construction of this statue, if either a party hired out to subcontractors for assistance. Payment for work meant how Reed was paid for the project, and whether or not Reed was hired regularly and consistently for projects required by CCNV. benefits and taxation were if Reed received employee benefits from the company and the taxation of the payment for the work created. Project management means who had the control of the outcome of the project. These were all determinants in the judge's verdict of the situation. Here's Sam, through the eyes of the entrepreneur.
This case has numerous implications for an entrepreneur and people planning on becoming an entrepreneur. Entrepreneurs need to make sure the terms of hiring an employee is obvious. This can become an issue if it is unclear to either party whether or not the employee is an independent contractor. An independent contractor, in terms of employment, is drastically different than standard employment. Employment status should be made clear in writing beforehand, before the work is started. Another aspect of this case that is relevant to an entrepreneur is the Copyright Act of 1976, Section 101, which Dan talked about earlier. This is the work made for hire clause. The terms of this clause are spelled out very, very well. This is significant to an entrepreneur because this could become a considerable issue, like it did for Reed in this case. Terms of employment need to be spelled out beforehand in writing to avoid these types of issues. If an employee is a work for hire, then the copyright belongs to the employer. The entrepreneur would need to keep this in mind if copyrights are in the scope of employment. In the opinion of our team, the judge did what was right. His verdict was fair and just. The copyright went to both Reed and CCNV. We feel this is just because Reed was the creator of the statue, yet CCNV got their share because they were an integral part of the creation of the statue and the completion thereof. Are there any questions or comments?